My name is Lynne Halem. I'm the director of the Center for Mediation and Dispute Resolution. We are located in Wellesley, Massachusetts. We often refer to ourselves as CMDR to make it easier and shorter for you. I have been mediating for over 40 years, most of the time at this location. CMDR specializes in mediation services in which people have relationships. So, for example, we do primarily 3 kinds of mediation. One is business mediation, and those are mediations involving small businesses. Like, we don't do major Fortune 500 corporations. We might do family-owned businesses or business partnerships or closely held corporations. We also do family mediations, particularly in areas that involve parents and children or children and children. For example, let's say somebody died in the family and the children are trying to figure out the terms of what to do with the estate because it isn't specified specifically in the will. So it would be areas that involve trusts and estates as well as interpersonal relationships. We also do, and I think I specialize more in this area than any other area, the area that involves couples either getting married and want a prenuptial agreement, couples who have custody issues, couples who are not getting married and are living together, couples who are divorcing. And all the areas with divorce has a lot of different components to it. So divorce is a very complicated area in the sense that it has a lot of subdivisions. I don't mean that it's particularly harder. I just mean that there are areas to cover because the agreement in Massachusetts has to go before the court. And if it has to go before the court, you have to make sure that your agreement will be approved by the judge. So that area also includes postnuptial agreements, people who want to stay married, but they also are nervous about terms if they should divorce. So it's a very broad area and has a lot of different components to it in a lot of different areas. So in Massachusetts, there is no such thing as a legal separation. So a separation agreement, like what are we going to do when we live apart, is going to be very different than a divorce agreement because it's not going to go before the judge because it can't. It's just not approved. There's just no provision for that in the law. So that's why there would be a big distinction between couples coming in and saying, we just want to, and I don't mean just, but they want to separate and stay separated. Now, there are couples who come in and they say they want to separate, but they want a divorce. And they want to know what they should do when they live apart prior to the divorce. So in effect, they're starting with the stage of separation, but they know that they're moving to the stage of divorce. So I'm not sure I answered your question correctly, but there is a big legal distinction between we want to live apart and never get divorced, or at least we don't think we do, or we want to separate because we're getting a divorce. There's a very big difference between mediation and counseling. So counseling would be relevant primarily, if you're talking about divorce, it would be relevant primarily if you're comparing it, well, I shouldn't say divorce, if you're comparing it to marital mediation, because marital mediation says, okay, we're not sure, we want a divorce or not, or our marriage is having problems, period. Do we go to a therapist or do we go to mediation? In that instance, people may do both. So therapists will often refer people to mediation whenever there's money issues involved, because they're not as comfortable doing money as they are in doing counseling, or they prefer not to. They simply, it's not even that they don't know it, they just don't want to. So they will refer people to mediation to deal with the money aspects of their marital counseling, and then they'll go back to therapy, or they'll be going to therapy simultaneously. But therapy is probing why things happened, what happened in the past, how do we change it in the future, how can we understand our behavior and our actions. I'm no expert, I'm not a therapist, but that's my understanding. Mediation is very, very different. We're focusing on problem solving going forward. So what someone did in the past, though clearly relevant to a couple or a family, or a business even, what someone, someone's past experience or their interaction in the past, though that's relevant in making a change, we're not looking at the origin of it necessarily. We're looking at, okay, what do we do about it? So mediation is a very problem-focused process. And a lot of people like it because of that, because your results are more instantaneous. Now, you might have a solution for a problem and you might pilot it in a sense and then find that you don't like it. And then you'll pilot a different one. But it's much more action-oriented, and it's much, it gives you early gratification. That doesn't mean it's better. It just means that it's different. The first session for people who are planning to divorce is to make sure that the couple is educated. And what I mean by that is I want to ensure that they know what the law says in all areas that pertain to their situation. So, for example, there is a law that has to do with child support. So if there are children, clearly they should understand that. If there are considerations of alimony, whether it's only one person considering it and the other is horrified by it, they still should both know what the law is as it pertains to alimony. And there should also be a consideration of how assets are divided. So in effect, if there's a couple who has children, there are 3 laws that pertain to them: the division of assets and liabilities, the kinds of support that would be paid, be it alimony and or child support. Those 3 things are absolutely critical. In addition to that, I want to make sure that they're able to provide the kind of information that's needed in order to reach decisions. So couples have to provide all information with full disclosure of their bank accounts, of their retirement accounts, of any kind of real estate they have, of any kind of brokerage accounts, on and on and on. And in order to make sure they do that, the very first thing in the first session, not necessarily the first thing in the first session, but to be covered in the first session, is to go over with them the assets and liabilities they have to consider, because sometimes they don't even recognize things as assets. For example, frequent flyer miles are an asset. Who would have thunk, right? And so we go through all of the things that they have to consider, whether they pertain to them or not. If they don't pertain to them, we just skip it, right? And so the key thing here is to make sure they understand what the law says and also know what they have to compile. You don't want them to think that they have to do it all at once, because it's impossible. I would lose people to paper. So instead of that, we decide, the 3 of us, the couple and myself, where is the first area that we should start? And then once we decide that, then I tell them what their quote unquote homework is. So they don't have to do everything at once, but they should know before they leave each time what they have to do for the next time. I follow up sessions with an email to both parties telling them what we covered, what kind of issues were raised, what kind of pending agreements they may have, what kind of information they need to bring in the next time, just to make sure that in the confusion and kind of angst that people bring to being together to discuss something like divorce, which doesn't make anyone thrilled, that they'll be able, when they go home, to say, oh, I forgot I have to do this, or yes, I know I now have to do this. So I want them to be informed, I want them to be knowledgeable, and I want them to do their homework so we could be cost effective and efficient. The truth of the matter is that mediation asks people to work together to create an agreement in which they'll be as whole as possible. We can't give them a pot of gold that they don't have. So I can't expand their wealth beyond what it is. On the other hand, we can be clever about what we do. We can try very hard to give Uncle Sam less and give them more. We can be careful with the taxes. We can analyze things. There are also a lot of things that can be done in divorce that can't be done in marriage. So for example, in divorce, you can as part of the divorce, you can transfer retirement funds from one party to the other without any tax consequences, unless you actually take the money out. You can't do that in marriage. You can't say to an employer, I want my spouse on my 401k. You can't do that. But you can do those kind of things in divorce, and people don't know that. They think they have to cash it in and pay the taxes and pay a penalty and everything else. So all of that's part of the learning process, but it's also part of being clever. So why do I think mediation is better than litigation? Litigation has two representatives, two attorneys, who are sworn by the Bar Code of Ethics to do the absolute best deal they can for their client. The best deal for each one person is not the best deal for both. And so we have to look, not necessarily a compromise agreement, but an agreement that somehow, by being creative, each person gets what they think is a fair agreement, and not only fair, but that it'll work. And it's, what is that old analogy about, if we were going to slice an apple up, how in mediation is that better than in litigation? Well, maybe one person wants to eat the inside of the apple and the other wants to use the rind or something like that. So it's really saying, how can we look at the same things, but answer each person's individual needs and priorities? I also think litigation is enormously expensive and destructive to future relationships. And if there are children, that is absolutely critical. I think the biggest misconceptions that people have about mediation is they think in general that there's only one solution for something, or maybe there are two. So let's make believe they have a house, and they think, okay, well, either one of us keeps the house and buys the other out, or we sell it. Those are the two possibilities. That is not necessarily true. It could be that they co-own the house for a while. Or I once had a couple that one lived in it for a year and then the other was to move in at the end of after the first year. What happened there was he was supposed to move in. His wife had been there first, and then he was supposed to move in. And then he said, you know what? I don't want to cut the lawn. I don't want to do the hedges. I don't want to live here anymore. And he changed his mind. But that wasn't the agreement. And that was fine. But the agreement was to give each one a year in the house. That's a very unusual agreement. However, my point is that by being creative and putting three heads together, not just the couples, but mine, because my head knows alternatives that the couple doesn't, because I've done thousands of divorces. So by putting heads together, we might be able to come up with something that both people feel, gee, I never thought of that. So it's the I never thought of it thing that is so surprising to people in mediation. So the question to ponder is, how has society changed over time and the law changed with it? And the reason I think that's such a fascinating topic is I wrote a book about that. Only my book is outdated now because it's older. So the way things changed then did not encapsulate all the changes that have taken place since I wrote the book. But the subject of how do things change is amazing. And yes, of course, at the beginning with same-sex couples, we had to deal with the fact that they weren't married, and we had to be so careful about how to create a separation when they weren't given the blessing of the law as far as marriage, what divorce law gave them and those rights. None of that. Poly families today clearly are a whole new development of using mediation to talk about the entrance into that kind of family. And how do you decide finances? How do you decide living arrangements? What if there are children involved? As well as non-financial issues of roles to be played and time to be spent, and how do you combine it if part of the couple is married? I mean, there's so many things that the intricacy of it comes more from the couples than anything else. Also, we're seeing many more quote unquote gray divorces, people who are getting divorced in their 60s and 70s and 80s even. And for those couples pondering, should we divorce or should we separate? Because their lifespan isn't the same as a couple that's 30. I mean, we wouldn't think it would be. And if they divorce, then they're dividing up an estate. And if they stay married, then beneficiaries and things like that are stay the same or can stay the same. So there's so many different things. And then there's today, we're dealing more with children with special needs than we did before. It's more visible. It's more is known about it. And so in an agreement with children with special needs, we want to be sure that the parenting plan accommodates for both parents' involvement in taking care of children who may require an awful lot of care, and over time, and how that will change over time. And so the development of society's acknowledgement of things that that society did not before has influenced how the law has changed, and it certainly has. A lot to the better, actually. The question to be addressed is, how do you prepare for a successful mediation? Or even more succinctly, can you prepare for a successful mediation? I think the key element in how do you prepare for a successful mediation, which sounds counterintuitive, I know, is to think about what there is about your spouse that you know that maybe somebody else does not know. And I don't mean deep, dark secrets. I mean, if somebody cares more about their retirement funds than their house, if someone is, whatever special about them, whatever focus would mean a lot, whatever their particular needs or concerns are, if you can focus on that one person that you know better than anyone else in the whole world, that will help you in negotiating, because you're negotiating with knowledge, and you're negotiating with an instinct to help find areas that your spouse would like that perhaps you would like something different. So just to summarize that, what I'm really saying is your knowledge of each other should be kept first and foremost in your negotiation. The other thing is to be careful that you don't draw a line in the sand. People have to be stopped from drawing lines in the sand, because it stops the negotiation dead and you can't go anywhere. If you say, well, unless you do this, I will not do that, anything, That's not a good way to mediate. What you can say is, this is really important to me. I want you to know that this is a real priority of mine, and it's very important that we deal with it, or it's imperative that we deal with it. But not that either you do this or I'm out of here, or I take my marbles and go home. So it's important to be open to the extent that you can listen to each other. You will learn from mediation how to communicate better. It is a tool that you take away. And that's one of the gifts of mediation. I think that it helps you in the future to communicate better with your then to be ex-spouse or your then ex-spouse, better with your children, better with other people. So it is an end result, or an end product, really. Parents who are getting divorced, or couples with children who are getting divorced, more precisely, are often very concerned about maintaining their relationship with their children. They're also sometimes overly concerned that their children will suffer, particularly people who come from families in which there was a divorce and they had a bad experience. They may worry endlessly that their children are going to be the byproducts of a bad divorce. The literature, of divorce, period. The literature on divorce is really, really clear. Children whose parents are able to parent together, their children do just fine. They are not the bad products of divorce. Parents who, on the other hand, pit their children against each parent, who continue to fight their divorce out over the year, their children do not do just fine. But I like to believe that my clients who come to mediations, children are good. I know that their children do fine. Lots of couples who come to mediation leave with a joint custody agreement where both parents are very active and almost equal members in parenting their children. For others, that's not a good solution. They prefer a solution where one parent has primary custody and the other parent sees the children, during the week and on alternate weekends or something like that. But it's not a 50-50 split. Sometimes parents do this arrangement that's called nesting. It means birds nesting is where nesting came from. And what that tries to describe is like the baby birds are in the nest, and the mama bird and the papa bird fly in and out of the nest in order to take care of the baby bird. So that translates into the children stay in the house, and one parent comes in certain days and then leaves, and then another parent, and the other parent, and then the other parent comes in certain days and is with the children, but the children do not leave. That kind of arrangement requires that each parent has someplace else to go. The most expensive way to do that is they each have a place to go. That is often too expensive. So sometimes they rent an apartment and one uses the apartment while the other one is in the house. The children are never in the apartment in that arrangement. I will say one thing about nesting: you cannot do it indefinitely, because neither parent feels the sense of privacy that you get from having your own place, be it an apartment or a house, doesn't matter. It's still yours, and nobody else is coming in and opening drawers or anything like that. So nesting is short term usually, but sometimes it provides an interim solution for the adjustment for the children, and it's fairly easy for children with respect to the children and not the parents, because they're not moving, they're just staying still. So nesting is sometimes not at the beginning, before the actual decision on where each parent will live, when the children then go to the house of each parent. I'm interested in mediation while I was getting my doctorate at Harvard. and I was studying how the law changed and in keeping with society. So as changes in society necessitated changes in the law was always lagging behind societal changes. So I began to study that as part of my doctoral work. I ended up writing a dissertation on that, and I ended up finally writing a book on divorce reform and how divorce in particular, divorce law, changed in keeping with societal changes in the law. I also studied, while I was at Harvard, the different impact on different populations of divorce, economically, as well as socially. I thought that I was going to stay being an academic, and I began to study cohabitation there and how people were living together that weren't married and that effect. And then I decided, with a friend of mine, to take a course on mediation, just as part of learning. And so we went to Maryland and we took a course there on how to be a mediator, and we were entranced by it, and came back and researched for 1 year the things we would need to know in order to mediate. I already knew divorce law because I had studied it as part of my studies at Harvard. And lo and behold, 40 years later, I am still doing the same thing. Lee Rainwater was a sociologist from Harvard, and I did want to take a course with them. He said, well, you're interested, so what do you care what the subject matter is? That changed my life, right? So I took the course, and in it, the guy who wrote the book asked me, I don't know why he asked me, he said, would you read the galleys of this book? So I took the book and I stayed through lunch, through dinner, called my husband and said, I can't come home, and read the galleys. I was so enthralled. It was all interviews with people that were getting divorced. And it was mind-boggling to me. So after I read that, I said, I'm going to do something as a study for this class. So I role-played a woman who was separated, getting a divorce. And my husband answered the phone I used the name Sheila Ash, God knows why. So there were phone calls. I took my daughter, who was 3, to apply for daycare, and they called her from behind. I gave her a different name, and they called her by this different name, and she didn't respond. They must have thought she was stupid because she didn't turn with her name, and so she loves to tell that story, how her mother dragged her around to daycare. But I did it, and I wrote a book about it. So it was cool. So in the words of my advisor at Harvard, he said, that book is sexier. Yep. The other book is more academic, is better writing kind of book, but this one's sexier. But anyhow, so they were both published eventually. I think it's important to ultimately talk about people's creativity, which is unbelievable. But it really is the problem-solving nature of mediation that brings out the creativity. It really does. And playing with ideas, which people don't do when there were 2 divorce lawyers, even if the lawyers were phenomenal. And even if the lawyers thought no matter what, they want these people to have a good settlement, and they care about the kids and everything else, the structure of I have my lawyer and you have your lawyer keeps them apart, and they're not able, it's not a brainstorming process, it's just not. And so it never covers the details that we can cover when we're together and say, okay, that's a good idea, and we do it. Instead, it's, oh, I'll check with my lawyer, and then my lawyer will check with your lawyer, and then your lawyer will check with you, and then we'll get back, and by the time they finish, it's like telephone.